Hi, everyone, and welcome to our talk about bond and parole. We'll get started in just a minute once more people join us today. All right, we'll go ahead and get started. Hi, everyone. Thank you so much for joining us this afternoon. My name is Stephanie Baez, and I am the Director of Pro Bono with the ABA Commission on Immigration. And I'm here with my colleague, Ambreen Walji, who's the Managing Attorney of the Pro Bono Program at the Immigration Justice Project. And we are very happy to talk to you today about bond and parole and how you can help migrants who are detained in ICE custody. So we'll go ahead and get started. For our roadmap today, we're going to start by giving an overview of what immigration custody is, and then we'll talk about bond and then parole, and then talk about how some factors about for pro bono representation and what the pro bono experience is like when working on these cases. But before we jump into everything, a quick note on why pro bono matters. A lot of the people joining us today might never have done immigration work before and are curious about how to get involved with pro bono work. Pro bono in the immigration context is really important because there's no right to a government-funded attorney for migrants who are seeking immigration relief. The government, on the other hand, is represented by a trained attorney, always in cases that go before immigration court. But for migrants who are new to this country, new to our legal system, might not speak English, for those individuals, they're not entitled to a government-funded attorney. And as many of you have probably seen in the news, the headlines are always, talking about this growing backlog in immigration cases and the high numbers of people that are coming over and that are in the system. And most of those people don't have representation. And the success rate in immigration cases does correlate with representation, as you can imagine. According to a report from the Transactional Records Access Clearinghouse, TRAC, which does a lot of data on immigration cases, in April of 2023, out of the people ordered removed from the United States in the past fiscal year, over 3/4 of those people were unrepresented, which follows. A lot of people, if they don't have representation, then they're not going to have a fair shake at presenting their case and explaining why they are eligible for the relief that they are seeking. And we're also going to talk today a lot about detained individuals. And there are some serious psychological and medical impacts of detention. And having a pro bono attorney who can help is really crucial for those cases as well. We're going to talk more about that in just one second. But a brief overview of the types of pro bono opportunities that you can get involved with if you want to work with the Immigration Justice Project in San Diego. There's research opportunities. There's the ability to work on appeals cases. There's merits cases, meaning some hearings in immigration court, like asylum or withholding or protection pursuant to the Convention Against Torture. There's representation before USCIS, which are more affirmative proceedings that involve more paperwork and possibly an interview, but less adversarial court setting. There are legal clinics that we are working on developing, and we'll keep everyone posted as those clinics come into play. And then today, the big one on the box there, the big box there is release from custody, bond and parole cases. And that's what we're going to talk about today. But I wanted to flag for you all that there are many different ways that you can get involved with pro bono. And we'll give you our contact information at the end. So if any of these opportunities interest you, you can reach out about these other topics as well. All right, now jumping into the meat for today, what is immigration custody? Immigration custody, when we talk about that, we're talking about people who are detained in ICE detention facilities. And the pictures here on this slide are pictures of the Otay Mesa Detention Facility, which is the facility in San Diego County. One important thing to know about immigration detention is that the majority of people who are detained in immigration detention have no criminal record. The statistic here, 74.2% of individuals who are in detention, in immigration detention, have no criminal record. And then of those that do have a criminal record, many of them are only for minor offenses like traffic violations. So one important thing to know is that when you're helping people who are detained in an immigration setting, we're talking about people who have no criminal record. They just happen to be detained because of their migrant status. At OMDC, Otay Mesa, there are approximately 1,300 people in ICE custody currently. And the primary nationalities that we're seeing there right now are people from Uzbekistan, Mexico, and Russia. Those populations change, as migration patterns change, but that's who we're seeing in detention right now. Conditions in ICE custody, as you can imagine, are pretty challenging and pretty difficult. One big issue is that people are separated from their family while they're detained. They can be detained throughout the entirety of their immigration case. And when that happens, it's very difficult to access evidence that might support their case because they have limited contact with the outside world. And it's really psychologically and emotionally challenging. I have a few quotes here from some of our former clients who have been detained. And one client who we'll call Rolando, his quotes about detention were that when he was there, quote, "I was very sick and was having rashes on my skin, and there was nothing I could do. I was scared and I did not know what was going to happen to me." He was separated from his two daughters, and he said, "I was feeling extremely depressed and sad, and honestly, I was crying in bed every night when I first got there." And for this client, his situation was further complicated because he was illiterate. He didn't understand the legal system or what was happening in his case. So he was getting his legal representation, his information from other detainees who were explaining to him how the legal system worked until he was able to connect with a volunteer attorney who could give him more information. And another client, a different client said, quote, "The detention by ICE was by far the worst experience of my life." And this is an individual who had lived in the United States for approximately 30 years before he was detained, because he had crossed the border when his mother fell ill in Mexico. And when he was returning, he was detained. He had 3 US citizen children who he was separated from. And he said that he spent every night, every hour in detention thinking of my children and dreaming of the day that I could see them again and we could finally be reunited. So that just gives you, a sense of the real emotional and human toll of what's going on for people who are detained in immigration detention. And now turning to the law. How is it legally that we are the U.S. government is able to detain people? That comes from the Immigration and Nationality Act, which we refer to as the INA or the Act. And Section 236A of the Act generally authorizes the detention of non-citizens pending a decision on whether that non-citizen is to be removed from the United States. And it permits people who are not subject to mandatory detention to be released on bond or conditional parole. So basically what that's saying is that generally non-citizens can be detained pending their immigration case throughout the entirety of their immigration case, but also there are mechanisms for release, bond and parole that can help people be released from detention during the pendency of their case. So we're going to talk about those two things in depth today. One quick note, when you see the Immigration and Nationality Act or other parts of our immigration laws, these codes use the word alien when they're describing non-citizens. And that's a word that many practitioners do not use just because it's dehumanizing. I mean, it's literally labeling someone as a non-human, as an alien. So it's not a term that we use as practitioners, but it is the word that, when you're quoting the law and the act verbatim, that is the word that's used. So just wanted to flag there for why you're seeing that on your screen. So if someone is going through the detention process and might end up being released or not during the pendency of their immigration case, there are a few different avenues that they can that might happen, a few different determinations that might be made when the government is deciding whether this individual should be kept in custody or not. Basically, when the Department of Homeland Security has an encounter with a migrant and places them in immigration proceedings, they can decide first whether the individual will be detained. And like I said, some people remain detained throughout the pendency of their case. Some individuals are released on their own recognizance. That means that they sign paperwork committing that they will appear for their scheduled immigration court hearings. And they're generally given a notice to appear in immigration court, and they will proceed with their immigration case as a non-detained respondent in immigration proceedings. Another option is that people might be given orders of supervision or placed on alternatives to detention. And that's where ICE might release an individual with certain conditions on their release, such as electronic monitoring, wearing a GPS ankle monitor, or periodically reporting to ICE either in person or by telephone. There might be some travel restrictions placed on those individuals. And those conditions can be placed, generally referred to as alternatives to detention, for someone who won't be detained in a facility, but they have these other ways of being monitored. And then the two main ones that we're talking about today are bond and parole. So a monetary bond is ICE can require someone to post a bond. It's similar to bail in the criminal court context, and that can help secure their release. Immigration laws require a minimum bond of $1,500, but the bond amounts can be much higher than that, tens of thousands of dollars. Or ICE can release an individual on parole, which is permission to reside in the United States for a finite period of time. And a quick overview of the difference between bond and parole, and then I'm going to turn it over to Anne Breen to really go more into the weeds and explain a little bit more of the details. The main difference to keep in mind between the two, highlighted in this chart. Like I said, a bond is an amount of money that a non-citizen pays to be released from detention. And the basic process there is that ICE can determine whether to set a bond for someone and how much that bond should be. And if ICE declines to set a bond or sets a bond amount that is too high, then the non-citizen can request a bond hearing, which Anne Breen's going to talk about more in just a minute. And that process is before an immigration judge, where they can ask the judge to set an amount. So that is as like a court hearing in court before an immigration judge, where they're asking the court to set a bond amount for them to be released from detention. And there's certain categories of people who are not eligible for bond. Parole, on the other hand, is permission to reside in the United States. And it's permission that ICE has broad authority to release non-citizens from detention via parole at any time during their immigration case. And requests for parole are not in court. Requests for parole simply go to ICE and can possibly go up the chain through ICE, depending on whether you're trying to seek review of those decisions, but they won't be heard by a judge. There's not a process in immigration court. So we're going to talk about those details in more detail. But for now, I'll turn it over to Anne Breen to go into more detail about bond.
Thanks, Steph. So as Steph mentioned, we're going to do an overview of the two most common ways that people get out of ICE detention that we see, which are bond and parole. Normally, when we're speaking about bond here in San Diego with immigration practitioners, when we say the word bond, we're normally talking about the custody redetermination hearing, the bond hearing. That is, as Steph mentioned, the hearing where you argue for your client before a judge that they should be released subject to a monetary amount that will essentially commit them to compliance with their court hearings and attending their court hearings. So the purpose of this monetary amount is to ensure that the detained individual attends their court hearings. And that's an important framework to keep in mind when you're framing your argument. So for example, past attendance at hearings is a relevant factor in making a determination. On the slide, you'll see the kind of trajectory of how people end up in detention. So there's the arrest by ICE, there's a first custody determination, and then your client or this individual might end up in detention. And then they'll have the second custody determination, which would be by the immigration judge. And that's why it's called a custody redetermination hearing. And it's generally, if you're arrested in the interior, if your client is arrested in the interior, it'll be the local field office that makes that initial custody determination. If they're arrested near the border, as is frequent in our region, CBP will make that custody determination. And both CBP and ICE are part of the Department of Homeland Security's DHS. As Steph mentioned, DHS can release someone on their own recognizance without requiring any monetary bond, set a bond, deny bond, or release somebody on parole. If they're not released right away, they will go to a detention center where they can request a bond hearing or to get an initial bond or to get a lower bond to be determined by the immigration judge. Next slide. Next slide, Steph. Thanks. Bond hearings are, as I mentioned, custody redetermination hearings because DHS has already made the initial determination. And they are before a judge where there'll be a trial attorney representing the government, your client, who is often if they're a client, they're represented by you, but the detained person or the migrant who is often pro se and representing themselves. The judge, there's often an interpreter that is helping to interpret for the court and for the respondent. And they are separate proceedings than their asylum proceedings. So it's a separate record. You have your bond proceeding, and it's a distinct record, and you have your immigration proceedings, your removal proceedings, which are a distinct record. Individuals, as Steph mentioned, have the right to be appointed by a counsel of their choosing, but no right to counsel. These bond hearings typically last in this area between 15 minutes and an hour, depending on the complexity of the case. In the past 3 years, you were able to appear remotely for a bond hearing, but this is changing, and we're seeing some judges require or prefer in-person appearance of the respondent's attorney at the hearings, but you can always present a motion to appear telephonically or by WebEx, which is the technology that is most commonly being used when appearing remotely now. During the hearing, the judge will set an amount, and the lowest amount dictated by statute is $1,500. Here in the Ninth Circuit, we can argue for no bond, no monetary amount for the bond based on a case of Hernandez v. Sessions, which said that the court must take into consideration the respondent's ability to pay. So that allows us to present on the equities that would be in favor of somebody not having to pay a bond. So whether those are that the person has been detained several years and has no and doesn't have a financial sponsor, has a place to live, but their sponsor doesn't have very much money. That's something that the court takes into consideration. Often, if someone has mental health issues and their ability to work, is not they're not able to find work as easily. If they were to be released from the community, that they also take that into consideration. And generally, just being detained is a consideration that we present that contribute to a judge making a monetary bond of less than $1,500, because when you're detained, you could make up to $1 a day, even if you do have a job while in detention. We try to request a bond as early as possible in someone's case. So their merits hearings are progressing, and we try to request the bond earlier in someone's case for the reasons that Stephanie kind of alluded to, which are that you have a lot more access to evidence, a lot more ability to present yourself, and the case moves slower when a person is not detained generally. Next slide. So who's not eligible for bond? Not everyone in immigration detention is eligible for bond, and we're seeing that it feels like less and less people are eligible for bond. There are certain individuals who are subject to mandatory detention. That's detention without the possibility of a bond hearing. And generally 3 categories of people are not eligible for bond hearings. Those are people who are subject to mandatory detention because of their criminal history. So people with certain crimes and convictions, especially those involving aggravated felonies, crimes involving moral turpitude, they may be subject to detention without the possibility of a bond hearing. The statute is broad in that it covers both conduct and conviction. But it's important to note that we cannot assume that ICE's determination of whether somebody is not eligible for a bond hearing is correct. you have to do your own analysis. So for example, when ICE might deem somebody as having a crime of moral turpitude, it's important to keep in mind that there's a petty offense exception, so they may still be eligible for a bond hearing. The other category of individuals who are not eligible for bond generally are individuals who have outstanding orders of removal or prior removal orders. These are individuals who have been previously ordered removed and have re-entered the United States, and they're in reinstatement proceedings. And that's subject to INA Section 235B. What we do if somebody is in reinstatement proceedings, one avenue to make them eligible for a bond hearing is to do some advocacy with DHS to ask that they be put in regular 240 proceedings. And so they would get the regular charging document and notice to appear, and their case would transpire as if they were not previously removed in the context of bond. And then there's a huge category, which are individuals who are arriving at ports of entry. Certain individuals who arrive at U.S. ports of entry seeking admission are deemed inadmissible and may be detained without a bond hearing. So we generally call these individuals arriving aliens. That means that they are ineligible for release on bond, so they have to remain, they can only request release through parole or to ICE, as opposed to in immigration court. Next slide. So this is a sample notice to appear. You'll see the three boxes 1, 2, 3 in about the midsection of the notice to appear, and that designates the legal status of the arriving non-citizen or the non-citizen when they are entering. So box 1 is someone who's never tried to, and someone who tried to enter at a port of entry seeking admission, and ICE determined that they didn't have lawful status to be there, and so they can be kept in custody as an arriving non-citizen. As I mentioned, you can challenge this designation. For example, if they did enter with a visa, but later their visa lapsed, you could challenge that designation, and that might be another avenue to have somebody be eligible for a bond hearing. Next slide. So we spoke a little bit about arriving aliens already, so I'm actually going to go past this slide. So non-arriving aliens is a category of people who entered without inspection, for example, or who were found in the interior without a lawful entry. And for a time being, about 2 years, these people were eligible for bond hearings, and they made up a huge portion of the people that we at IJP represented in bond proceedings. There was a case that was enjoined, that's matter of MS, that said that any non-citizen who is transferred from expedited removal to regular removal proceedings after passing a credible fear interview is not eligible for bond hearings. And that case was enjoined for 2 or 3 years by Padilla and ICE. That is now no longer the case, and matter of MS is back in effect. And what this means is that those people who may have climbed over the fence in order to get to the U.S. or entered, in any way without inspection, and then were presented to a border official once they were in the U.S. or were found for some other reason by Customs and Border Patrol, were previously eligible for bond hearings are no longer eligible. So now very few of the clients that we encounter are eligible for bond hearings, which makes advocating to ICE for release even more important. So this is just a checklist of the analysis that you'll want to do when meeting your client for the first time and considering whether or not what avenue for release you're going to pursue. So if the client is an arriving alien, they will not be eligible for bond. If the client is mandatorily detained because of their criminal history, they will not be eligible for bond unless there's a way to challenge that classification. So just keep that in mind. The law is evolving. We're hoping for better law on the horizon, but right now it's a very limited pool of people in detention that we meet that are actually eligible for bond. And I mean, in that sense, it does open them up to a representation by a class of attorneys that, you know, who might not have been interested in taking on their cases because for fear of being in immigration court and presenting before a judge. Parole, as Stephanie will speak about, is even more important.
Great, thank you, Ambreen. So now I will jump in and explain a little bit more about parole. As we've discussed, parole is a pathway for individuals in immigration detention who would like to be released that go through an administrative proceeding. And the purpose is to ask ICE to release your client from detention through this administrative proceeding. It is not a proceeding in immigration court. There's no opposing counsel. There's no judge involved with this. DHS may grant parole for any non-citizen applying for admission, including arriving alien asylum seekers and those in expedited removal. So I'll talk more about expedited removal, I think, on the next slide. But so those categories of ineligibility that Ambreen was just describing for bond, such as arriving aliens or people who are placed in expedited removal and going through a credible fear interview process, individuals who might not be eligible for bond could still be eligible for parole. Doesn't mean their parole will be granted, but they can at least seek parole. So the eligibility for parole is broader as compared to bond. And before I move on to the next slide, I just wanted to pick up on the thread that Ambreen just laid down about why parole cases can be really wonderful pro bono cases, and it can be a great introduction to immigration for someone who has never been involved in immigration before or who has never litigated before. Frequently, we have transactional attorneys who might be interested in volunteering in pro bono with immigration, but they have it in their mind that immigration is really just for litigators because it's court proceedings. And certainly transactional attorneys can do court proceedings, but sometimes people are a little more hesitant. And so parole cases are a great way to get involved, to work with the client and make a life-changing difference, but to do it based on some paperwork, which we're going to describe now as we jump into this without a court proceeding. So one of the topics that we've been talking about is credible fear and this process of expedited removal. So I wanted to pause and chat about that a little bit more, since, as Ambreen mentioned, it's something that really we've been seeing a lot of with our cases, that this has been having an impact. So expedited removal is a process where immigration officers can quickly deport certain non-citizens who are undocumented. So it's basically a fast track for removal. But expedited removal, there's a certain process that someone who is seeking asylum must go through a credible fear interview process before being subject to expedited removal. So basically, if someone says that they fear persecution, that they fear returning to their home country because they fear being persecuted, they'll go through a process called a credible fear interview, which is basically a screening interview where asylum officers will determine if that individual, the non-citizen, might be able to establish an asylum, withholding of removal, or protection under the Convention Against Torture case in immigration court later on. So the CFI, the credible fear interview, CFI, doesn't determine whether that person, for the most part, that doesn't determine whether someone's going to be granted asylum. There's a few other rules why I'm hedging my bets, because there's a lot of different processes. But for what we're talking about right now, CFI is not going to determine necessarily whether someone's going to get asylum, but it does determine that they've passed the initial screening where they're not going to be removed right away. They're going to have a chance to present their asylum case in immigration court. So the CFI frequently takes place while someone is detained. And the general rules around that are that if someone is awaiting their decision on their CFI, then they can request parole under the section of the code is 8 CFR 235.3. And that's for people who are waiting for their decision on credible fear. Generally, for those individuals, they need to show that there's a medical emergency or that their release from detention is necessary for a legitimate law enforcement objective. On the other hand, after the credible fear determination, if someone has been granted, they've received a positive determination on their credible fear, then generally it's ICE policy that they should be released if they received a positive CFI determination. And then when they're requesting parole after a credible fear determination, they're requesting it under 8 CFR 212.5, which is the same code that they would be using if they were in removal proceedings, not expedited removal, but just plain old removal proceedings without a CFI. And under that provision, basically we're looking at the ICE will be evaluating on a case-by-case basis, looking whether there's an urgent humanitarian reason or a significant public benefit for why this individual should be released from detention. So as I've mentioned, parole is not a court proceeding, it's this administrative proceeding. So the basic process is that an attorney will submit a packet of documents to their client's deportation officer. And what they need to put together, the first document is a G-28, which is a notice of entry of appearance. So it is a document indicating that you are this person's attorney and that that you're going to be representing them in their parole request. But importantly, you would not be filing a document called an E-28, EOIR-28, which is what people file when they're representing someone in immigration court. For these requests, you're simply representing them for parole, which is not before immigration court. And then as part of the packet, attorneys draft a letter or a memo letter that explains certain things, which I'm going to jump into in one of the later slides, but they'll explain why their client is not a flight risk, not a danger to the community, and basically why they're requesting parole and kind of weigh the factors for why parole should be granted for their client. They also need to include information about a sponsor. A sponsor is someone who basically vouches for your client and says, if they're released from detention, they can live with me, and this is the address where they're going to live. If they have financial needs, I can pay for them. I will cover them. Basically, just letting ICE know that if this person is released from detention, they'll be provided for, that there's somewhere for them to go. And that's really important. We'll talk more about sponsors in just a second. But basically, you'll need to include your the identification of a sponsor and proof of the sponsor's status. A sponsor really preferably should be a U.S. citizen or a legal permanent resident of the United States. And then the sponsor needs to draft a letter of support that says, how they can support this individual. You need to provide any proof of income, proof of address, and copy of identification for both for the sponsor and for the citizen, the client that you're trying to help, the non-citizen that you're trying to help. And then also any other documents that might support your argument that there's urgent humanitarian reasons or a significant public benefit for why your client should be released. This can include whether your client has any special medical needs, whether there's any pregnancy or disability, any harm that might happen to someone based on their gender identity. Those types of things, if any of those factors exist in your client's situation, it's really important to provide evidence and to emphasize those factors as well. So looking into some of those things in a little more detail, I mentioned the attorney needs to write a memo or a letter supporting why their client should be released. And some of the key things that you need to show in your letter first are that your client is not a flight risk. The flight risk is basically looking at whether your client is going to appear for their immigration court hearings. ICE wants to know, if we release this person, are they going to show up? Are they going to be coming to their hearings? Are they going to go through the process? And some of the factors that they look at when evaluating that are whether this individual has any ties to a community in the U.S., whether they are part of any religious groups, education groups, any community ties that they might have here in the U.S. Their family ties in the U.S. If they have any U.S. citizen family members, that's really important to write about and to emphasize, who are their family here in the U.S. Whether they have a history of steady employment. And that doesn't just, that's not just in the United States, but, in their home country, can you show that they've had a history of showing up for a job, of being gainfully, steadily employed? And then any information on your client's potential ultimate immigration relief. So what form of relief have they applied for, or do they intend to apply for? And how likely are they to succeed on that claim? Now, importantly, Ambreen mentioned this with bond, and it's the same with parole. Bond and parole are not about proving your client's underlying merits immigration case. So bond and parole aren't about proving whether your client is ultimately going to win their asylum claim. The merits portion is a separate case, a separate record, as Ambreen mentioned. But it is helpful when arguing why someone should be released from detention. It is helpful to share that this is the relief that we think that they're eligible for, and they're likely to win this relief because of XYZ reason. The rationale being, if someone is likely to receive immigration relief, they're more likely to show up for their hearings. They're more likely to, participate in the process and move forward because there's this, this chance that they're going to succeed in the end. And so that's something that is helpful to argue for, if your client has experienced persecution, if your client, whatever their factors might be for the immigration relief that they're seeking, it can be helpful to explain that here, even though that's not being adjudicated at this time. It could help weigh into the decision of whether to release someone from detention. The next big thing that's important to show is that your client is not a danger to the community. You want to show that if they don't have any criminal history, you want to say that they can have a sworn declaration to that effect. They want to, show that they have no criminal history. If there is a criminal history, then that does need to be addressed. There's that does it, and to show how long ago a criminal conviction might have occurred. And has the client been rehabilitated since then? Has the client participated in any anger management courses, any AA courses, anything that might go towards showing that this crime happened. Best case scenario is if a crime happened a long time ago and they've done taken some affirmative steps for rehabilitation, then those can be included to show why this person is not a danger to the community. And then we touched on in the last slide the importance of a sponsor. So like I said, a sponsor is someone who can verify where the client is going to live and how the client can pay their expenses if released from detention. And we include generally a letter from a sponsor whenever possible to help support the parole request. And in this next slide, I'll go a little more in depth on what is your sponsor letter. It can be fairly straightforward, basic letter, but it's got to have some really key information, which would be the name and the full address and phone number of the sponsor. Generally a statement saying, I've attached a copy of my US passport as proof of my citizenship status, or if they're a legal permanent resident, then they can attach a copy of their green card, whatever documents they might have to show their status in the US. And then a brief description of how they know the detained individual. It doesn't have to be a family member. It could be a friend. It could be, they don't have to be related, but you want to explain basically how this person knows the detained individual and kind of why they are willing to step up and be their sponsor and help them. And then the letter should say that upon the detained individual's release from detention, if they can come live with the sponsor, then what the address is of where the person will live. The sponsor, we will cover necessary expenses, including housing, food, and other living expenses, and we will transport the non-citizen to and from his immigration appointments. That kind of language from someone basically just verifying that they're going to be there to support this individual once they're released from detention, and that they will support the individual financially and also support the individual in attending their immigration hearings and other appointments. And then the sponsor can say whether they have the capacity to pay if a parole bond is required. And that can be kind of a confusing term because we've been talking about bond and parole. Sometimes under parole, which is this administrative process that we're talking about, the non-court process, sometimes parole might be granted with a payment attached, which would be a parole bond. Basically just means a monetary payment attached to the parole release. And if that happens, the sponsor should, say whether they could pay that if in the event that that happens. One of the big challenges with parole is that sometimes you send off your request, the parole request, once you put your packet together, you can email it to your client's deportation officer, usually sending by email. And sometimes you don't hear anything for a while, and a week passes and maybe another week and another week, and you're in limbo. It's really important when you're representing someone who has a parole request that you are persistent, that you keep contacting their deportation officer to follow up and to see what's going on and what the status is. Every day that someone is in detention is extremely psychologically challenging, and it's really, really important. Time is crucial here. A week is huge, both for someone's psychological well-being, emotional well-being, and also for someone's immigration case. Ambreen mentioned earlier that immigration cases move faster for detained individuals. And it's harder for them to get their evidence, to get their documents, to present a case for their underlying merits, their asylum case, for example. That's much harder to prepare a case while someone is detained, and their timeline is much faster while they're detained. So both for purposes of giving them the best shot at being able to present their case to an immigration court, and just for the psychological impacts of being detained, it's really important to be persistent and not just to send off the packet and assume that someone's reading it, or that you're going to hear from them. Sometimes things get lost. People don't focus on it, don't follow up. And so you, as your client's advocate, are the number one person who is just going to be persistent, as persistent as possible, to make sure that someone's actually reviewing the request. But then what happens if the request is denied? It's possible that the deportation officer can tell you why it was denied. So the first kind of line of defense, or the first outreach, would be to the deportation officer. If it's denied, your client's deportation officer could tell you specifically, like, we were concerned that this person is a danger to their community, or the flight risk, we're concerned about flight risk. We don't see the the arguments there. They might be able to give you that information. They might be able to tell you that more evidence is needed. Maybe you submitted certain types of evidence, and they want to see, let's say, utility bills to show that someone has been in the U.S. paying utilities in addition to paying rent, or whatever it might be. They might say that there's certain evidence that was deficient that they want you to plug in, or whether maybe there's some documents that need to be notarized. They want, who knows? There might be something that they can give you the clue of why it got rejected. And you can keep renewing the request. So if it was denied and they tell you broadly, this is why it was denied, maybe you have more evidence that can help you with that argument, and you can resubmit your request. If they give you the specifics of this is why it was denied based on these specific things, that's great. That's a big, roadmap to help you for how you can beef up the request and renew the request if it is denied. If the request is denied and maybe the deportation officer isn't giving you anything, and it's been denied and you just don't know why or where to go with it, you can seek supervisory review of the parole request, which is basically by sending an email to the supervisory deportation officer. This is kind of more of a local level of review to raise it up the chain. And if you're still having trouble and need to escalate it further, then you can escalate the request through the ICE case review process, which is basically it's the national headquarters of, where you could send this to escalate, that would look over the request after the local field office has made its decision, its denial. So there is steps for elevating this request. But importantly, what's absent from this slide is there's no review by an immigration judge. There's no court review here. The process just gets escalated up the chain with ICE, without there being any judge or court review. So now we're going to talk about the specifics of pro bono representation in these cases, and I'll pass it back to Ambreen.
Thanks, Steph. So Custody representation, whether it's bond or parole, looks very similar, as you might have gathered from this presentation. The main distinction between parole and bond is parole, you're advocating for release to ICE, and bond, you are advocating for release to an immigration judge. Because bond, you have to go before the immigration judge, you have to register with the Executive Office of Immigration Review. It's a very simple process, which can be done almost entirely remotely. I think actually the last portion, which you had to present identity documents, can now be facilitated remotely as well. And it takes about a day or two to get registered. It's limited in representation. You're not taking on a full case. As we mentioned, it's distinct from the merits representation, from the removal proceedings. And remote representation is possible, though it's becoming more and more common for an immigration judge to expect you to attend in person. For parole, there is no requirement to meet in person with the deportation officer, for example, or even your client. For the last 3 years, we've been placing volunteers to take on parole cases entirely remotely. The reason why this training is in particular geared towards local Southern California attorneys is because the people who are in detention are now expecting and hoping for their attorneys to meet with them at least once in person, and to have that face-to-face contact. But similarly, similarly to bond, you present the equities as to why your client is not flight risk or danger to the community. And you have to do that instead of a brief, which you would do in a bond hearing. You would present that in a letter, as Stephanie mentioned. And there's no litigation, and it is entirely up to ICE whether they release your client. In both cases, your client is released from detention, and we've spoken a little bit about why that's significant, but I'll just mention another reason. A lot of the clients that we have, as soon as they're put into immigration detention, they're completely cut off from everyone they know. They don't have access to cell phones. They have very limited access to phone lines because they have to pay to be able to make phone calls, and that basically cuts off their connection to their family back home or their friends back home, which means that when they're collecting evidence, they're relying on somebody who's in the community, maybe their attorney, to be able to collect the evidence from their family back home. They don't have access to email and so on. So release from detention is significant for their case, and as Steph mentioned, it's significant for their well-being. Generally, detention resembles something similar to the trauma that they've experienced. For a lot of people, the trauma that they've experienced in their home country that led them to flee and seek asylum in the United States. Detention can really parallel a lot of the aspects of harm that they experienced when the reasons why they left their home country. Next slide. So some of the challenges in parole and bond cases are, kind of straightforward. Something you would imagine. It's challenging to be able to create rapport when you're doing things remotely, but in making that connection in person and in scheduling and having legal visitation with your client, that is time consuming. There are times when the facility is not accessible, when the detained person is not accessible to their attorneys. That's when they're doing count, when they're in quarantine. So we've had a number of outbreaks at our detention facility, and I think it's common knowledge that there was a COVID outbreak at our facility not too long ago. And since then, we've seen other quarantines, whether it be varicella and so on. And so that means that your communication to your client to meet in person is really restricted, but they're still accessible by the phone here and there. But the phone lines themselves are not the most reliable, whether messages get back and forth to call you back, etc. There are also challenging cases. We do see clients with criminal history and who really are fighting an uphill battle to get out of detention. And sometimes they'll have submitted their own parole request pro se, and we'll see a denial. But then with an attorney with their own declaration, they've you've contacted their family member back in their community, and they're able to present all these certificates, how they were an A+ student, and that can really beef up a parole request. They're able to present letters from their children and so on, who they're looking to be reunited with. That makes a huge difference, and that's something that they're unable to present necessarily pro se, or at least piece together as eloquently as an attorney can often. Then we often see challenges with respect to flight risk. Many of the detained people that we work with do not have sponsors in the United States, and so really they have almost no shot of getting out unless they find a community sponsor. And so with an attorney, they can have their attorney reach out to the sponsors that we know who often take on and help people get out of detention. For example, Casa Marianela, which is a community sponsor that vouches and provides housing and writes letters in support of getting people out of detention. Then finally, as Stephanie mentioned, ICE responses are unpredictable. You might have two parallel clients with parallel sponsors and very similar stories and present them to ICE, and ICE might grant parole within a week for one of them, and it might take several months and several follow-ups and escalation to get the other person out of detention. This can be extremely frustrating as people make friends in the detention center and talk to their buddies about who's getting out and who got out, and they're telling their attorneys. So it's hard to manage client expectations. But really, I think a person who has an attorney is much better off than somebody who doesn't, especially in those situations. Next slide. So taking on a detained case, I think I mentioned, or maybe I didn't, that people can be moved around at a moment's notice from facility to facility. So it's important to know what the ICE locator is. That's kind of a database where you can look for your clients and find out if they're at the detention center. In order to meet with somebody and have a legal visit at the detention center, you need to present your bar card and state ID. Also interpreter clearance. Just a little note about interpreters. We used to rely entirely on volunteer interpreters for the cases that our volunteers took on. We are now able to offer some phone interpretation through a language line. But when meeting with your client in person, you just want to make sure at the facility, you have to call in to make sure that there's a room available with a telephone, so that you can call out and get a language interpreter on the phone. So that's a huge benefit now that we have this interpretation, because you don't have to work around the schedule of another volunteer when you're taking on a case. I think I mentioned about registration with the Executive Office of Immigration Review. And finally, because their merits cases are fast moving, you want to begin working on your detained custody case as soon as possible. You want to be contacting your client sponsor, contacting your client, or arranging a meeting for your client, filing your G-28 with the deportation officer so that they know to communicate with you. You want to do that within a week, because it really does make a difference. Next slide. A note about the impact that volunteers make. We recently had a volunteer represent somebody who had been detained for 429 days. That's through the COVID pandemic. That's somebody who had filed parole applications before, and they were finally able to get released at a time when their son had been born. They had been detained when their partner was pregnant, and they met their son for the first time. And when he FaceTimed his attorney, he couldn't stop laughing. He was a very serious person in detention, but the attorney said that it was incredible to see him giddy with joy in being with his son. So it's not just about their asylum case or being detained, it's also about their actual dignity and humanity.
Absolutely. And so we'll just close out in our final few minutes here, just talking about what's available to you as a volunteer if you decide to take one of these release cases with IJP. First, IJP does offer malpractice insurance, so you have the benefit of that. That's something you don't need to worry about on these cases. But one of the other big reasons why pro bono is helpful for people new to immigration and immigration practitioners alike is the benefit of having mentorship. On these cases, you'd be mentored through mentors with the ABA Commission on Immigration and IJP attorneys, with office hours to support you, webinars, written guides provided. Um, you would have a mentor who's basically with you every step of the way. So we're very used to volunteers who do not have prior immigration experience, who are doing this and it's the first time, and we totally understand how nerve-wracking that can feel, and how it can be a little bit scary. But that's why we're here, is to provide the support, and to really help you throughout your time representing someone. And we've had plenty of people who've had no litigation experience, no immigration experience, and have come on and taken these cases and have made a huge difference. And you know, of the people that I was talking about at the beginning, who I gave some quotes from clients who had been detained, and how to really, you know, express the challenges of being detained. One of them, after working with a IJP pro bono volunteer, said, after being so grateful being to spend time with his daughters, quote, "I don't know if I would have gotten my life back without my lawyer." And the lawyer who helped him was a transactional attorney who had never litigated, never done immigration work before. And she described the process of mentors hosting weekly office hours where she could call and talk about all of her questions. She could reach out with emails, online resources available to her. And she said, "I was given a tremendous amount of resources in terms of legal and procedural support. I had the most amazing mentors. I was never overwhelmed, despite the gravity of what might happen to my client, because I had excellent mentorship." So I'll just leave you with that plug to let you know, if you do take on one of these cases, you really will be supported. And here is contact information. So if you're interested in a case, you can reach out to probono@abaijp.org. And also, we'll send out a follow-up email to everyone who's been on this call today, and give you more information as well for how you can get involved. And I think we just have 2 minutes left, so we can open it up for questions. And I see one that came in the chat box, from someone who said that they previously worked in Virginia, and when a case was escalated up the chain of command, a parole case, I think, escalated up the chain of command, that they saw some retaliation. A more severe deportation officer would be assigned. Someone might be removed to a remote detention center without notice. And wondering if there's observations about what that looks like, if that's been happening here or elsewhere, if anyone else on the call has thoughts on that. Ambreen, what is, in your experience, is that something that's happened when requests are escalated?
So I haven't had that happen when parole requests are escalated. I've seen it happen when someone files a grievance with the facility, that they have been moved in retaliation to a more remote detention center. Generally, with parole requests, the deportation officer will just ignore it, if anything, and even as it's escalated to the ICE case review, it will be ignored for, you know, months until the field office finally responds. But I haven't seen a move like that. That's not to say it doesn't happen. I just haven't seen it, and I haven't heard of it happening here.
Good to know. Thank you for that information. Hopefully it's a little bit, you know, less retaliatory here than what you experienced in Virginia. Does anyone else have any more questions before we wrap up today? All right, I'm not seeing anything else come through. So thank you so much for joining us. We'll be sharing these slides and the recording, and sending up a follow-up information in email with more information about how you can get involved. But thank you so much for spending your lunch hour with us today.
Bye, everyone. Thank you.